Almighty God, we give thanks to you, the Creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this House here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen.
Oath or affirmation. Announcements by the Deputy Speaker.
Honourable members, I have received communication from 1. Mr. Dinesh Rambali, MP, Member for Shogunas West. 2. Mr. Arnold Ram, MP, Member for Caroni Central. And 3. Mr. Devindranath Tanku, MP, Member for Urupuch West, who have requested leave of absence from today's sitting. The leave which the members seek is granted.
Bills brought from the Senate on the supplemental order paper, the Anti-Gang Bill 2021 in the name of the Attorney General. Petitions, papers.
The Minister of Public Utilities.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, I have the honor to lay the following paper. The annual report and audited financial statements of the Regulated Industries Commission for the year ended December 31st, 2015.
Reports from committees, Prime Minister's questions, urgent questions.
Member for Caroni East.
To the Minister of Health, in light of reported plans to purchase Sinopharm vaccines from China, does the government have a contingency plan should World Health Organization approval not be granted in the short term?
I call on the Minister of Health.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, as we have stated many times, both in and out of the Parliament, the government, in addition to bilateral deals with China and or Sinopharm, is also pursuing the purchase of vaccines through the African Medical Council's platform, 1, through the COVAX facility, 2, and bilateral talks with both countries and individual vaccine manufacturers. We have said that both in and out of the Parliament on many, many occasions. Thank you very much, Mr. Deputy Speaker.
Supplemental.
Member for Caroni East.
Yes. Can the Minister confirm that a pre-order from Sinopharm, as reported in the newspapers, has been made?
Minister
Thank you very much. As I indicated, we have placed indicative orders with Sinopharm and indicative orders with everyone we are talking to pending approval. So we have given them an indication that we would like X thousand number of vaccines. So the answer is we have placed indicative orders pending approval and pending their manufacturing capacity to provide those orders.
Still on my first question, he didn't answer it. I would like to know what the number X stands for.
Member, hold on. Do you have another supplemental question?
Before I go to this other...
Member, no, 1 second.
Okay, no problem.
You cannot query or ask a question.
Okay.
Do you have a next supplemental?
Yes.
Kindly proceed, member.
Can the Minister indicate when we are likely to receive our first allocation from the COVAX facility?
We are informed by PAHO, again, all things being equal, that the 33,600 doses should be here by the end of March. That is the current timeline that COVAX has given PAHO and which PAHO has passed on to us. Thank you very much.
Member for Faizabad.
Thank you, Mr. Deputy Speaker. To the Minister of Health, In view of the publicly reported intentions of private entities such as Ansa Macal and the Supermarkets Association of Trinidad and Tobago to take responsibility for providing COVID-19 vaccinations for their own employees, could the Minister indicate what process will be utilized to facilitate these entities?
Minister of Health.
Thank you very much. For completeness and transparency, I will read extracts of a letter which I sent to Ms. Frances Bain Cumberbatch, Chief Legal and External Affairs Officer of ANSA. Please note that the policy of the Government of Trinidad and Tobago is that only WHO-authorized vaccines may be imported through a local distributor, provided that the vaccine has been approved through the national regulatory process pursuant to the Food and Drugs Act. In this regard, WHO-authorized licensed vaccines may be found on WHO's website. We ask the following questions. What is the source of these vaccines? Are these vaccines coming directly from SII or through the local AstraZeneca agent in Trinidad and Tobago or through another third party outside of Trinidad and Tobago? If the vaccine is being sourced through any other third parties listed above, please identify the third party and provide the necessary documents to confirm that the said third party is authorized by SII to distribute vaccines in Trinidad and Tobago. The Ministry of Health also requires specific information on the COVID-19 vaccine batch numbers and expiry dates. We also want evidence of the cold chain maintenance. And we said, lastly, it should be noted vaccine manufacturers have indicated that all purchasers shall enter into an indemnification and liability agreement. That is what we told Ansa Macal. To the Supermarket Association, Mr. Rajiv Dipti, same thing applies, I won't repeat it. March 17th. We also asked Mr. Rajiv Dipti, please provide the name of your authorized local distributor importing vaccines on behalf of the Supermarket Association. We advise him, same liability issue, same cold chain issue. We also asked him, because in his letter to me, he indicated that 2 private entities, medical associations, medical hospitals have partnered with him to distribute these vaccines. When I called those private hospitals, they have absolutely no knowledge, no agreement with the Supermarkets Association to distribute vaccines. So that issue seems to be clouded in the controversy. The objective of this government is not to sacrifice the safety of the population for expediency. How could the Supermarket Association write to me?
Supplemental, member for Faizabad.
Thank you very much, Mr. Deputy Speaker. Minister, thank you for that answer. Minister, can you guarantee that regardless of who eventually procures vaccines, that the distribution process will be prioritized on the stated rollout plan of your government to immunize those most at risk first?
Thank you very much.
Minister of Health.
Let me start by saying it is dangerous to call a private medical institution as partnering with you, and when the Minister of Health calls that institution to verify, they claim absolutely no knowledge of that. Let me put that on the record. I have put on the record publicly several times. Depending on the supply of vaccines, we will stick with the stated hierarchy. I have also said publicly, if we get more vaccines, if supply starts to exceed demand, we may look at doing things not in parallel, but concurrently. So I have said that publicly, and I hope that answers your question. Thank you very much.
I recognize member for Oropuchis.
Mr. Deputy Chairman. Mr. Minister, this matter, as you're aware, has been in the public domain for about a month now. You have written on March 17th, which I believe is 2 days ago. Have you received any response to your letter as yet? And will you also call, since you are very proactive in calling?
Member, one question. Which question would you like him to answer, please, member?
Have you received any response, whether in writing or otherwise?
Thank you very much. Yeah. So, Mr.
Deputy Speaker, he needs an Indian injection. Laventil West is disturbing me. I cannot hear the answer to the question that I'm asking. Laventil West is disturbing me. I really would like to hear the answer from the Honourable Minister.
Thank you, member. Again, members, it's very early in the sitting. I recognize the Minister of Health.
Thank you very much. Mr. Rajiv Dipti wrote me on Monday, the 15th of March. On Tuesday and Wednesday, the 15th of March, Mr. Dipti put out a press release stating they are working with the Ministry of Health, which was absolutely false. I responded to him in writing on March the 17th, which is 2 days ago. After the media started to bombard me, asking me what is the nature of this collaboration between the government and the Supermarkets Association. And I responded on March the 17th. On March the 17th, I called the private hospitals that Mr. Dipti claimed to have partnered with. And in the interest of the safety of this population, it is shocking that these private entities have denied all knowledge of any partnership with the Supermarket Association. So he wrote to me on the 15th, he went public a day later, and I responded on the 17th. Thank you very much.
Before I move on to the next question, again, it is very early in the sitting, and the mutterings and murmurings that I'm hearing from various members, please desist. And also, members, remember, you are not to sit with your back to the Speaker's chair. I will now recognize the member from Maruga Tableland.
Thank you, Madam Speaker. Given the recent landslip, thank you, Mr. Deputy Speaker, sorry. Given the recent landslip along the Madingo Road that has damaged homes, could the Minister state whether critical funding has been identified to alleviate this urgent problem affecting thousands of motorists and citizens? Thank you.
I recognize the Minister of Works and Transport.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, contrary to what was put into the public domain by residents of the area that the Minister of Finance have not released any money to the ministry, that is a false statement. The ministry have not been able to identify anybody saying that. The answer is yes, the ministry have identified funding. In explaining on what that means, I need to let you know the steps that will be taken. In the first instance, the region, the area is prone to this type of landslips activities based on a number of factors, the main being the soil type. As such, we are engaging with a specialist affiliated to the UWI to analyze the soil type. Out of the results, we will be able to pursue solutions for a medium and long term. Immediately, we will try to restore one lane of traffic via shoring and piling. However, we know this will not hold without doing the necessary geotechnical surveys. I thank you.
Member from Maruga Tableland.
Thank you, Deputy Speaker. The Minister said urgent action will be taken. Can I ask the Minister, when will relief work start as families are under pressure today?
Minister of Works and Transport.
Mr. Deputy Speaker, urgent works comes in several aspects. As I said, we will attempt to do some shoring and piling to secure at least one lane on the roadway while we await the geotechnical surveys that will be undertaken by a specialist geotechnical engineer. Thank you.
Supplemental again, member from Maruga Tableland.
Yes, Deputy Speaker. Given the government's liability or culpability as reported by those affected, can the Minister give any assurance on whether compensation is going to be provided for homeowners who have suffered damages?
Minister of Works and Transport.
Mr. Deputy Speaker, the question is based on information from the homeowners. I am sure there's a process if there is a need for compensation, and that process does not lie with the Ministry of Works and Transport. So I cannot give any undertaking for such.
Member for Couva South.
Thank you very much, Mr. Deputy Speaker. To the Minister of National Security, given reports in the public domain which have revealed that 92 officers attached to the Central Division of the Trinidad and Tobago Police Service are currently in quarantine due to COVID-19, could the Minister inform this House of the total number of police officers across the respective divisions of the TTPS who are currently in quarantine?
Minister of National Security.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, as the country is aware, and through you, the way that the Ministry of Health personnel and experts have been dealing with COVID-19, and the advice is, once a person tests positive, there's a contact tracing exercise that takes place. Primary contacts, secondary contacts, and even tertiary contacts, which are the most distant, are immediately sent on quarantine as a precautionary measure. And that is exactly the protocol that was followed in the current matter. Mr. Deputy Speaker, furthermore, there are not 92 officers in the Central Division on quarantine as a result of that contact tracing exercise. There are 87 officers. Out of those 87 officers, 3 were positive, 2 are primary contact, and 82 are secondary contact in the Central Division. The whole police service, meaning police officers as well as TTPS employees currently on quarantine, including those 87, is 128.
Supplemental, member for Couva South.
Thank you very much. Minister, given the statistics that you have revealed, could you inform this House if the Freeport, Couva, and Chaguanas police stations are up to strength in terms of their respective operations, taking into consideration the shifts that law enforcement officers are engaged in?
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, the Commissioner of Police and the administrative arm of the Trinidad and Tobago Police Service would have put the necessary arrangements in place, and I am certain that they have sufficient cover in those areas. Additionally, the whole ERP system would provide additional coverage in those instances, but that falls completely under the purview of the Commissioner of Police. And in fact, I've seen a letter from the member for Couva South to the Commissioner of Police recently asking for certain meetings, etc., to take place, and that is going to happen. The Commissioner of Police has given that assurance.
Honourable members, the time for urgent questions have now expired.
Answer.
Leader of the House.
Thank you very much, Mr. Deputy Speaker. There are 10 questions on notice for oral answer. We'll be answering all. There are no questions for written response.
Member for Tabakit.
Question number 77 to the Minister of Education.
Minister of Education.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, the Teaching Service Commission is the body responsible for the filling of vacancies in the teaching service and not the Ministry of Education. In addition, the process for recruiting teachers is quite time-consuming, and in the circumstances, notwithstanding the general freeze on filling of vacancies in the public sector in fiscal 2021, the Commission is continuing its work so that teachers can be employed as necessary and when funds become available in order to ensure continuity of education to our children.
Supplemental, member for Tabakit.
Speaker, Can the Minister indicate how many vacancies currently exist in the teaching service?
Minister of Education.
Mr. Deputy Speaker, that information is not currently with me. It can be provided at a later time, but the interviews and so on are still going on to ensure that they'll be filled.
Would the Minister be able to say how many vacancies would have been filled in the past year? Did you know that?
Minister of Education.
Mr. Deputy Speaker, the information that is being required is very specific, and I will have to get that from the Teaching Service Commission.
Member for Tabakit, other question. Question number 79.
Question number 79 to the Minister of Education.
Minister of Education.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, the Ministry of Education, in collaboration with the National Information and Communication Technology Company Limited, IGovTT, has completed the procurement evaluation exercise for 20,000 laptops and has recommended the award of contract to Memory Bank Computers Limited for the amount of $45,700,000 Trinidad and Tobago dollars, VAT non-applicable. The letter of award was issued to Memory Bank Computers Limited on Tuesday, 2nd February 2021. The procurement unit of IGovTT has finalized the 2 contracts required to manage funding and the completion of the procurement of laptops, which are the parent contract with the Ministry of Education and the contract with Memory Bank Computers Limited, and these will be signed shortly. Notwithstanding, Memory Bank Computers Limited has indicated that the laptop devices were ordered from its supplier on the date of the letter of award, with a 1 to 2 month time frame for delivery of the laptops to the Ministry of Education.
So, from your
Member.
answer,
Go ahead.
the delivery would be to students would be within 1 to 2 months. That's correct.
The
Minister of
arrival of
Education.
the arrival of the laptops in Trinidad and Tobago will be within 1 to 2 months. So we are now in March, and we expect that they will begin to come in April of 2021.
They would be delivered to students. The laptops would be delivered to students by April 2021. Yeah?
Minister of Education.
The delivery of the laptops in the country, the arrival in the country, will be April 2021. We are expecting the first batch, because we are advised that they will come in batches. They will arrive in the country in April 2021, subsequent to which we will deliver them to students.
Okay.
Question number 80, member for Tabakit. Proceed.
Thank you very much. Thank you very much, Mr. Deputy Speaker. To the Minister. Minister, can you give us the criteria in which the laptops will be distributed to the schools? For example, the process for the distribution of these laptops?
A whole different question.
Another supplemental?
Yes, please.
Proceed.
Can the Minister explain what procurement process was used for these laptops?
Minister of Education.
Thank you. Mr. Deputy Speaker, the Ministry would have worked with IGovTT, who would have engaged the procurement process and sent out a tender, and responses to those tenders were evaluated, and one was awarded to our contractor.
Final supplemental. Proceed.
Can the Minister indicate whether or not this was by sole select tenders or whether by advertisement?
Member, I'm not hearing you too clear.
Can the Minister indicate whether or not this was done by sole select tendering, please?
Members, please. Minister of Education.
Thank you, Mr. Deputy Speaker. It was not sole select. The RFP was open to bidders.
Member for Tabakit. Next question.
Education.
Minister of Education.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, as for physical school, the attendance of students online is taken every day as a record of student attendance in the virtual classrooms. Where students have repeated absences, as is the procedure physically, schools would make attempts to contact parents involving the staff of the Student Support Services Division. Students who are having difficulty transitioning to the virtual environment have also been able to benefit from the services of school social workers and guidance counselors online and face-to-face under COVID-19 protocols where necessary. In addition to this, the Ministry of Education continues to facilitate the donation of devices to students by corporate citizens to bring more students into the online environment, even as the delivery of the 20,000 devices is expected imminently. The Ministry is also arranging the procurement of 1,300 devices from CAF UNICEF at this time to ensure that our students have equal access to virtual home-based learning.
Supplemental member?
Thank you for your response, Minister of
Proceed.
Education. The question sought to talk about who the students who have been able to access virtual school but dropped out of the virtual school system. So in our joint select committee, we were told that
Question, please.
some 47,000 students would have dropped out. So I'm asking specifically, given that information came to the public domain within the last 2 months,
Question, please, member.
have there been any additional plans or programs put into place given the data that we currently have today?
Minister of Education.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I am not sure of the veracity or the context of what the member has quoted in terms of figures, but I am certain that students who are not present on the online environment, who have access to the virtual environment, they are contacted through their teachers, by their parents, through the Social Services Division, to ensure that if any issues arise with their attendance, that is sorted out to the best of the ability of the teachers and the school social workers and guidance counselors.
Supplemental member for Tabaki.
Student support services, given that they would bear a significant responsibility in terms of keeping students within the virtual school system.
Minister of Education.
Thank you, Mr. Deputy Speaker. The school social workers have been trained to deliver online, and they have also been in contact with the students face-to-face, so that there is no gap in the delivery of their services, so that if there are students experiencing difficulty, they are able to intervene whether online or face-to-face as necessary.
Member for Couva South.
Thank you very much, Mr. Deputy Speaker. Question number 84 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Mr. Vice President. Deputy Speaker, Mr. Deputy Speaker, in the budget statement of fiscal 2021, the Ministry of Works and Transport was mandated to take immediate step to rationalize by the end of fiscal 2021 the operations of the Port Authority of Trinidad and Tobago and to introduce a private sector operator into the port handling operations now carried out by the Port of Port-of-Spain. The purpose of this mandate is a measure to significantly improve the efficiencies of the operations of the port and reduce the economic burden that the port currently places on the existing commitments of the state. In this context, Cabinet in October 2022 agreed inter alia to the establishment of a Cabinet-appointed committee to consider the arrangement of the privatization of the Port of Port-of-Spain. The committee mandate was to address the following matters: the current state of the Port of Port-of-Spain and the implications of its continued operations, an insight into the operations of the world's top private-run ports, the preferred approach to a PPP for the Port of Port-of-Spain, and the recommended roadmap for the privatization of the operations of the port, along with timeframes and successful completion. The committee comprised representatives from the following state entities and civil society groups under the chairmanship of the Minister of Public Administration and Digital Transformation, the Ministry of Public Administration and Digital Transformation, Ministry of Finance, Ministry of Trade and Industry, Ministry of Works and Transport, Urban Development Corporation of Trinidad and Tobago, Trinidad and Tobago Chamber of Industry and Commerce, Trinidad and Tobago Manufacturers Association, and President General of the Seamen and Waterfront Workers Trade Union. In addition,
10
to the
more seconds,
aforementioned-
member. 10 more seconds.
Oh.
Finish.
Mr. Deputy Speaker, the final report was submitted for the consideration of the Cabinet by the Ministry of Planning and Public Administration and Digital Transformation. The chairman of the committee, in this regard, the Ministry of Works and Transport, awaited decision from the Cabinet on the way forward.
Supplemental, member for Couva South.
Could you inform this House whether the report of the committee, which was headed by the Minister of Public Administration and Digital Transformation, that went to the Cabinet of Trinidad and Tobago,
Question, please.
did not have the final sign-off of the stakeholders, inclusive of the Seamen and Waterfront Workers Trade Union?
Minister of Works and Transport.
Mr. Deputy Speaker, I don't understand that question if there is a sign-off. This was a committee that submitted a report. I don't know if what the member is speaking about have signed off from the union, if that is a requisite of the report. The report has been submitted to Cabinet, and the Ministry at this point waiting for a decision.
Supplemental, member for Couva South.
I'm simply asking whether the report which went before the Cabinet of Trinidad and Tobago, there was a meeting which finalized the report and had the concurrence of all the stakeholders before it went to the Cabinet of Trinidad and Tobago.
Member, 1 second. Member,
yes.
Couva South, ask the question directly, please. Proceed.
Thank you very much, Mr. Deputy Speaker. Minister, the report of the committee that was headed by the Minister of Public Administration and Digital Transformation on the restructuring of the port of Port of Spain, that said report, which is before the Cabinet of Trinidad and Tobago, did it have the sign-off and concurrence of all the stakeholders before it was submitted to the Cabinet?
Minister of
Mr.
Works and
Speaker,
Transport.
a report was submitted to the Cabinet. I do not have the information as required. If that information is required, I'm willing to, on a future question, to be posed, and the information will be sought.
Thank you very much, Mr. Deputy Speaker. Mr. Minister of Works and Transport, could you inform this House whether there has been a timeline agreed to by the Cabinet of Trinidad and Tobago to implement the recommendation of the said report on the restructuring of the port of Port of Spain?
Minister of Works and Transport.
As indicated, Mr. Deputy Speaker, the Ministry of Works and Transport would have been given a mandate by the end of this fiscal year. The report has been submitted to Cabinet, and until that report comes back to the Ministry of Works for a direction, only there and then we will be able to get that time frame from the Cabinet.
Member for Moruga, Tableland.
Question 85 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you again, Mr. Deputy Speaker. So, Deputy Speaker, the Highway Division of the Ministry of Works had proposed a program for sectional paving work to be executed in fiscal 2020-2021 via the award of contracts. However, because of financial constraints, many of these projects that were identified could not be undertaken. As an interim measure, the Highway Division, through the Victoria East District, conducted periodic spot patching as part of its routine maintenance work along Hindustan Road, together with the limited patching at the Naji Road. The Victoria East District proposed to undertake sectional paving work along the Naji Road in fiscal 2021-2022. This will be subjected to the availability of funding. I thank you.
Supplemental, member for Moruga, Tableland.
Thank you, Deputy Speaker. Is the Minister aware that this particular location is home to the Devil's Woodyard volcano facility, which has been earmarked as one of our local tourism sites, and that the road leading to this facility is in a deplorable state?
Which is the
Which question, member?
which is the question?
It's only one question. Which question would you like answer, please?
With regards to the Minister said that patching would have been done on the Hindustan Estate Road, and this was not so. The road is in a deplorable state. So
Right. Member, 1 second.
okay, that's a statement. Okay.
Yes, the question, please.
Okay. What would be done with regards to the Hindustan Estate Road or the road in the upcoming future, since the Minister is stating that the works was due to funding reassigned?
Mr.
Members, please. Member
No,
from
I
Ruga
needed the
Tableland.
youth facility assistance.
Member, 1 second. Member from Ruga Tableland, I'm giving you the opportunity to ask the question to the Minister. Kindly proceed now, please.
This particular area is home to the local tourism site of which is the Devil's Woodyard, and that.
Right. Question now, please. Yeah, you could give the question now. Proceed.
How soon could something be done within this area?
Minister of Works and Transport.
Mr. Deputy Speaker, as indicated in the original answer, as an interim measure, the Highways Division through the Victoria East District conducted periodic spot patching and as part of its routine maintenance work along the Hindustan together with the limited patching at the Naji Road. The Victoria East District proposed to undertake sectional paving work along the Naji Road in the next fiscal year. However, continuous in-house patching and maintenance will occur and is being done as we speak.
Supplemental, member from Ruga Tableland.
Could the Minister indicate how long these works will take to be completed?
Minister of Works and Transport.
So, Deputy Speaker, routine maintenance work is done on a daily basis, and whatever work have been started for the day is completed in that day. So it's routine maintenance.
No. Member for Couva South. Member for Couva South, please. Honorable members, I'm on my legs. Members. Member from Ruga Tableland, next question.
Question 87 to the Minister of Public Utilities.
Minister of Public Utilities.
Thank you.
Listen, members, please. It is now 2:08. The session has only started just over 30 minutes ago. And if it is that this is the way we would like to proceed, again, as the Speaker in the chair, we will act accordingly. So again, members, question to the Minister of Public Utilities, please proceed.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, the Water and Sewerage Authority supplies water to the Mark Village and the Ruffin Road from the Trinity Water Treatment Plant. Well, you know what it is. WASA has advised there is presently a shortfall between available volumes and the demand for water by the residents of Moruga. Similarly, Mr. Speaker, Deputy Speaker, the communities that are affected in Princestown are supplied through the Navet transmission system and are affected by continuous maintenance issues at the St. Julian Booster Station. The St. Julian Booster Station needs to be upgraded to transmit larger volumes of water to these residents on the extremities of the system.
Supplemental, member?
In light of what the minister just itemized as the problem, can the minister state if any assistance will be afforded to these families through tanks, water tanks?
Minister of Public Utilities.
Mr. Deputy Speaker, the Ministry of Public Utilities has a social program where we assist members of the community who request water tank assistance. They can go online and make the requisite application. And once they are deemed suitable, then their application will receive consideration.
Supplemental, member for Muruga Tableland.
From what the minister described in his statement, everyone in that area should be deemed suitable. But my supplemental question is regards to would any assistance be given through truck-borne water, and is there a funding or increased funding due to what he just described?
One question only, member.
Would any assistance be given through truck-borne supply of water?
Minister of Public Utilities.
Mr. Deputy Speaker, yes, the truck-borne service is always available to members of communities that are affected by low water supply, and if constituents of the member for Muruga are affected and they can request the requisite services from WASA, it will be provided.
Supplemental, member for Princestown.
Speaker. Mr. Deputy Speaker, to the Honourable Minister. Minister, about 2 years ago, government announced a replacement of the infrastructure in the Tableland area. Can you indicate whether or not this project has commenced and will be able to assist in alleviating the challenges in the areas identified in this question?
Member for Minister of Public Utilities.
Mr. Deputy Speaker, my response to that question is that once funding is available, the requisite infrastructure work will be instituted in the communities.
Next question, member for Muruga Tableland.
Question 88 to the Minister of Public Utilities.
Minister of Public Utilities.
Thank you very much, Mr. Deputy Speaker. To improve water supply to residents of the Muruga Tableland area, WASA is proposing to undertake extensive infrastructure works, including the upgrade of the Trinity Water Treatment Plant, the upgrade of the booster pumping stations, the construction of a service reservoir and substantial pipeline installation and replacement. Mr. Deputy Speaker, the works outlined by WASA to improve supply in the Muruga Tableland require significant capital injections. We are all aware that the country is challenged by the current economic climate, and as a result, the infrastructure improvements will be undertaken when funding becomes available. Mr. Deputy Speaker, I can assure the residents that the situation in Muruga Tableland is under close investigation. The Ministry of Public Utilities is working on a water stabilization plan that would improve the water supply around the entire country while improving the efficiency of the Water and Sewerage Authority. The execution of this program will also be subject to the availability of funding.
Tableland.
Mr. Speaker, could the Minister indicate what is the total cost for improving the water supply?
Minister of Public Utilities.
Mr. Deputy Speaker, I do not have that information at this point in time.
Supplemental, member.
Could the Minister indicate what percentage of the constituency has pipe-borne supply of water?
Minister of Public Utilities.
Mr. Deputy Speaker, I do not have that information at this point in time.
Member for Naparip. You have a supplemental, Princess? Proceed, member.
Thank you, Mr. Deputy Speaker. Minister, in light of the question that was just posed by the member from Muruga Tableland, there was great fanfare 2 years ago when you all indicated that the cost was 18 million. Can you indicate whether or not this has been abandoned? The identified cost that was announced by government 2 years ago was 18 million.
Member, we have a question there already.
Yes, I'm asking whether or not this
project has been abandoned. The Honourable Minister indicated he could not give a figure. We were advised 2 years ago that it would cost 18 million.
By whom?
The project. Has this project been abandoned?
Thank you,
or
member.
is it something that will be pursued by government?
Member, thank you. I will not entertain that question at this time. I now proceed to member for Naprima.
Question number 100 to the Minister of National Security.
Minister of National Security.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, body cameras are not individually distributed to police officers, but rather to units and divisions of the Trinidad and Tobago Police Service in order to maximize their operational usage. Accordingly, as at March 5th, 2021, the Trinidad and Tobago Police Service would have distributed over 140 body cameras to several of its units and divisions for use by officers whilst on duty. The Trinidad and Tobago Police Service has also been granted approval for the purchase of an additional 500 devices. All of this falls under the remit of the Commissioner of Police, as he's in charge of the financial and administrative aspects of the Trinidad and Tobago Police Service.
Supplemental, member for Naprima.
Thank you. The Commissioner of Police indicated in July 2020 that an order has been placed for 1,000 body cameras. Could the Minister indicate what is the status of that 1,000 body cameras?
Minister of National Security.
Mr. Deputy Speaker, that information will have to be derived from the Commissioner of Police. I don't have that information here.
Supplemental, member for Naprima.
The Minister is responsible for policy. Is it the government's policy to have all police officers who need it, given their duties, equipped with body cameras? And if so, what is the percentage?
That is two questions.
Which question, member?
Is it the policy of the government to have all police officers who need it equipped with body cameras?
So, Mr. Deputy Speaker, the policy of the government and the discussions between the Minister of National Security, myself, and the Commissioner of Police is that it is advisable that as many police officers as possible be provided with body cameras. Ultimately, the administrative side of decision-making is that of the Commissioner of Police. So it's up to him to determine. So recently, he, along with his administrative arm, were determining whom in the police service should be given body cameras. The government's policy is as many police officers as possible who are interacting with the public should be given body cameras.
Supplemental, member for Naprima.
Has the Minister, in discussions with the Commissioner of Police, gone beyond as many body cameras as possible to give a percentage figure in terms of police officers?
No.
Member for Naprima, next question.
Question number 101 to the Minister of National Security.
Mr. Deputy Speaker. Thank you. Mr. Deputy Speaker, the government of Trinidad and Tobago is unable to provide information on this matter as it is now sub judice, as there are several matters related to it before the High Courts of Trinidad and Tobago.
Has the Minister been able to indicate? Has the Minister been able to indicate what is the status of these stranded citizens in Syria?
Are you in a position, Mr. Minister? Proceed.
I don't know what he means by stranded citizens. There are persons who are in detention camps in northern Syria who are claiming to have citizenship in Trinidad and Tobago. I cannot say anything further with respect to this, as the matters are currently before the courts.
Supplemental, member for Naprima.
Mr. Deputy Speaker, has the government not even sought to find out if the claims are true, if they are citizens or not?
The answer is yes. The government has been through a verification process that is currently ongoing. Apart from that, there's nothing further that can be said.
Mr. Deputy Speaker, this issue has been going on for about a year and a half.
Question?
For a year and a half. Is the government, does it take more than a year and a half to find out whether they have been cared for or whether they are suffering?
Minister of National Security.
Mr. Deputy Speaker, these are refugee camps and prisoner camps in a war zone, a conflict zone. The government certainly has no personnel and no state representative there to carry out any first-hand verification exercise. In those circumstances, we depend on other agencies to provide information, and that exercise continues.
Next question, member for Naparima.
Question number 102 to the Minister of National Security.
Minister of National Security.
Mr. Deputy Speaker, during the period of May 31st, 2019 to June 14th, 2019, the government embarked on a migration registration project in order to determine the accurate number of Venezuelan nationals in Trinidad and Tobago. This registration exercise was aimed at all Venezuelans in Trinidad and Tobago, whether they were here legally or illegally. The government has decided to undertake a re-registration process for these Venezuelan migrants, which is currently underway, having started on the 8th of March 2021 and will continue at this time until the 26th of March 2021. The objective of this exercise would be to update the information on Venezuelans who participated in the original migration registration framework exercise in 2019.
Supplemental member for Naparima.
Is the minister going beyond the 16,000 that were previously registered in order to find the accurate number of Venezuelans in Trinidad?
Minister of National Security.
Thank you very much. Mr. Deputy Speaker, there are a number of ways that the government derives information with respect to migrants, not only Venezuelan migrants. That information is derived in addition for the Venezuelans, in addition to the re-registration exercise from our immigration officers and from the Trinidad and Tobago Police Service and the Defense Force when they come across Venezuelans who may not be properly registered and legally here in Trinidad. In addition to that, immigration would have the necessary records of Venezuelans outside of the re-registration and the registration exercise who have been granted permission to be here, for example, via the provision of visas.
Supplemental.
Mr. Deputy Speaker, Mr. Minister, the anecdotal evidence indicates that there could be between 40,000 to 60,000 Venezuelans in Trinidad and Tobago. Are you in a position to confirm a figure?
So,
Minister of National Security.
Thank you. Mr. Deputy Speaker, that anecdotal evidence very often comes from the mouth of the member for Naparima. What we know is in 2019, an exercise was conducted that allowed any Venezuelan who was present in Trinidad and Tobago, whether here legally or illegally, to register himself or herself. 16,500 registered during that exercise, which completely showed the provision of 40,000, the suggestion of 40,000 Venezuelans in 2017 present in Trinidad and Tobago as being extremely unlikely. So in addition to what this re-registration exercise is doing, there are records, as I just said, with immigration and our protective services that will also give the government a more valuable and accurate figure of Venezuelans who are here in Trinidad and Tobago than anecdotal suggestions.
Supplemental member for Naparima.
I'm thankful. Is the minister confirming that he does not know the number of Venezuelans resident in Trinidad and Tobago?
I will not entertain that question, member.
Managers are imps.
Move the adjournment of the House on definite matters of urgent public importance, statements by ministers, personal explanations, introduction of bills, motions relating to the sittings, to the business or sittings of the House, and moved by Minister of Public Business, Government Business, bills second reading.
The Attorney General.
Thank you. Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, I beg to move that a bill entitled An Act to Amend the Mutual Assistance in Criminal Matters Act, Chapter 1124, be now read a second time. May I, just because I sit in both houses, ask what the time in this house is again?
30 minutes.
Thank you very much.
30 minutes. The responder will also have 30 minutes, and all other members, 20 minutes.
Thank you, sir.
So we start now.
Mr. Deputy Speaker, it gives me great pleasure to pilot the introduction of this amendment. The bill before us is intended to address an immediate and important improvement to the manner in which mutual assistance in criminal matters is provided. Mr. Deputy Speaker, the parent law itself, the Mutual Assistance in Criminal Matters Act, Chapter 1124, was born by Act number 39 of 1997. It's been amended on 4 occasions, most notably in 2001, where Section 40 of the Parent Act was amended, and I'll come back to that. In 2005, where significant amendments and improvements were brought into existence into the law, and in 2018. And this particular law, the Mutual Assistance in Criminal Matters Act, is the embodiment of Trinidad and Tobago's commitment to providing assistance to other countries divided between 2 pots, Commonwealth countries and non-Commonwealth countries, in respect of criminal matters. In the Parent Act, a Commonwealth country, at Section 2, means a sovereign and independent country within the Commonwealth, other than Trinidad and Tobago, and includes dependent territories. Criminal proceedings, which is what this is all about, means, for the purposes of the Act in the various regards, proceedings which have been instituted or in investigations which have commenced in Trinidad and Tobago or elsewhere. In other words, then, criminal proceedings includes from the moment that police authorities are involved in investigations, they can reach out to Trinidad and Tobago, or Trinidad and Tobago can reach out to Commonwealth countries and non-Commonwealth countries for mutual assistance in criminal matters. It's important to note that we are, in the body of this law, treating with a serious offense. And a serious offense in relation to Trinidad and Tobago is an offense against the laws of Trinidad and Tobago for which a sentence of death or imprisonment for a minimum term of not less than 1 year may be. In other words, then, only criminal matters under 1 year by way of an offense and conviction are to be excluded. Anywhere from above 1 year right up to the sentence of death can be the subject of proceedings for mutual criminal assistance. It's important to note that Section 4 of the Parent Act is relevant to this debate today. Section 4 says, the Attorney General may, by order, direct that the application of this Act in relation to a particular Commonwealth country shall be subject to such conditions, exceptions, or qualifications as are specified in the order, and in that event, this Act shall apply accordingly. In other words, then, Section 4 of the Act relates to all Commonwealth countries, and all that needs to have is an order is specified which may or may not provide limitations or exceptions. In this Act, the Commonwealth countries that have already received the benefit of the order are Canada and the United Kingdom. Section 33 of the Parent Act, which this bill proposes to amend, is where we treat with non-Commonwealth countries, and that is under Part 4 of the Parent Act, and it deals with the application of the Act to countries other than Commonwealth countries. A non-Commonwealth country is defined as including countries that are simply outside the Commonwealth, and importantly, a treaty is referred to in Section 32, and a treaty is described as including a convention, protocol, agreement, or arrangement. Now, it's very important to note that under Section 16 of the Interpretation Act, the singular includes the plural, and therefore a treaty includes a multilateral treaty and, of course, a bilateral treaty being just the bare minimum treaty that you could have. So a treaty includes multiple treaties, including multilateral treaties. Section 33 of the Parent Act, which the bill proposes to be amended, as I welcome you to the chair, Madam Speaker, is such that where a treaty has been entered into between Trinidad and Tobago and a non-Commonwealth country, providing for mutual assistance in criminal matters, then, upon the application of the country for assistance, the Attorney General may, by order, subject to negative resolution, declare that country to be a country to which this act applies. This means specifically that for non-Commonwealth countries to receive the benefit of intrusive criminal assistance on a mutual basis, as described under the Act, we must have a treaty with that non-Commonwealth country. That means that there is a severe limitation for non-Commonwealth countries, and in fact, the only non-Commonwealth country that is the beneficiary of a treaty at present is the United States of America. It's important to bear in mind that this law is not to be confused with extradition. This law is mutual assistance in criminal matters. We seek today to improve the pot of non-Commonwealth countries by amending Section 33 of the Act, and in fact, we are borrowing from the precedent in the amendment obtained in 2001 to the Parent Act, where we amended Section 40 of the Parent Law, specifically in the addition to Section 1A, subsection 1A of Section 40, we added in 2001 that where a treaty has been concluded, whether before or after the commencement of this Act between Trinidad and Tobago and any other territory, providing for mutual assistance in criminal matters arising or criminal offences committed in Trinidad and Tobago or such other territory, not including a criminal offence in relation to subsection 1, which is to deal with drug trafficking offences, the Attorney General may, by order, subject to negative resolution, declare the treaty to have force, etc. Now let's translate what I've just said, because it was important to put it in the context of the law. Fact is, Trinidad and Tobago is a member of several multilateral treaties, including the Intergovernmental Agreement with the United States of America, including its entry in a fulsome context to the Global Forum, including its entry into the FATF world. Trinidad and Tobago is a member of the following multilateral treaties on criminal matters. Number 1, the UN Convention Against Drugs 1988. Number 2, the UN Convention Against Corruption of 2005. Number 3, the UN Convention Against Transnational Organized Crime of 2000. Number 4, the UN Rome Statute of the International Criminal Court of 2002. Number 5, the Inter-American Convention on Mutual Assistance in Criminal Matters, 1992. And number 6, the Inter-American Convention Against Illicit Manufacturing and Trafficking of Firearms of 1998. We are also members of the following double taxation treaties. Double taxation treaties with Brazil, Canada, CARICOM, China, Denmark, France, Germany, India, Italy, Luxembourg, Norway, Spain, Sweden, Switzerland, United Kingdom, United States of America, and Venezuela. We are the beneficiaries of multilateral and bilateral treaties in the bilateral context with the United States of America under the IGA, the Intergovernmental Agreement, and in the Global Forum context, we will become bilateral participants with 190 countries. Now, the international law demonstrates, if we have regard to precedents around us, when one has a view of the Mutual Legal Assistance in Criminal Matters Act of Canada of 1985, the Mutual Assistance in Criminal Matters Act 1987 of Australia, and the Crime International Cooperation Act 2003 of the United Kingdom, when one has regard to these laws, it is clear that the distinction between Commonwealth and non-Commonwealth fell apart several years ago in the international context. And in that regard, Madam Speaker, the parent law in the definition section, Section 2, refers to the scheme, referring to the Harare scheme. And I would like to put on record that the scheme relating to mutual legal assistance, the Harare scheme, is a scheme which we are the beneficiaries of and which we have modeled, And in that, being the scheme adopted by Commonwealth law ministers in 1986 in Harare in Zimbabwe, there has been a significant amount of reconsideration, and amendments and upgrades were done in 1990, in 2002, and in 2005. And very importantly, the Commonwealth has produced model legislation in its meetings in Edinburgh, in Scotland in 2008, and moving right through to September 2013 when draft model legislation was presented. And that draft model legislation is the subject of scrutiny at the AG's office right now. That draft model legislation removes the context of Commonwealth and non-Commonwealth. It specifically includes the modern technologies that are in existence, such as factoring information technology, interception of communication, the digital environment, the manner in which cybercrime affects all of criminality across the globe. And therefore, we propose specifically to introduce today the step before a full repeal and replace of this legislation. The step that we propose to introduce today is intended specifically to introduce an amendment to Section 33 of the Act. And the amendment, as set out in Clause 3 of the bill, is very specific. It says, where Trinidad and Tobago and a non-Commonwealth country are both parties to a treaty, and a treaty, of course, includes a multilateral treaty, concluded whether before or after the commencement of this Act, and which contains provisions dealing with criminal matters, and there is no arrangement for mutual assistance in criminal matters between Trinidad and Tobago and that company, then upon application of the country for assistance, the Attorney General may, by order, subject to negative resolution of the Parliament, declare the treaty as an arrangement to provide for mutual assistance in criminal matters, in respect of criminal matters falling within the scope of that treaty. We, of course, put the limitation to say that it shall not continue for longer than the treaty's existence. What does this mean? Any one of the United Nations Convention treaties that I've just mentioned, any one of the IGA agreements, the Global Forum context, all of them having arrangements set out for mutual assistance in criminal matters are therefore liable, upon the request of any country sitting in those pots, to ask for mutual assistance in criminal matters. The Attorney General can approach the Parliament by having an order subject to negative resolution, and therefore the intrusive aspects of assistance in criminal matters can then apply. And what are the intrusive aspects? Those intrusive aspects are set out in the parent law in Part 2, Part 3, and then in miscellaneous aspects beginning Part 5 and Part 6, which has the tail end of the coming into force of treaties, etc. Specifically, it allows obtaining of evidence, locating or identifying persons, search and seizure, attendance of persons, safe conduct, assistance in securing prisoners in transportation, transfer of prisoners, serving documents, return of documents, restrictions on evidence, immunities and privileges, tracing of property, certain orders in relation to obtaining restraining orders, financial assistance. We then go down to the manner in which we treat with escaping, transiting, and arrest of persons, etc. What does this mean? The interrogation of criminal matters in the global network are allowed now without discrimination to apply to Trinidad and Tobago without reference to these two pots which our law currently creates, that is Commonwealth and non-Commonwealth. It takes us now to a step closer to the modern version of Mutual Assistance in Criminal Matters Act, having removed the limitations set out against tax matters being interrogated and investigated, as we did in 2018 when we repealed Section 22(2)K of the parent law, which provided an ouster for tax matters. We now allow for complete investigation of matters. Madam Speaker, it's important to bear in mind that Trinidad and Tobago has so far, as a matter of fact, and I want to say that I'm not permitted to go into the details of requests now before the central authority, as I myself, as central authority, the figure point, am subjected to secrecy provisions that we just passed in law not more than a month ago. And that new Section 41 of the Act, therefore, restrains me in the kind of information I can offer today to the Parliament. But I can say that we are dealing with corruption, money laundering, terrorist financing, allegations in certain cyber matters, discreditable conduct, child matters, pornography, etc., attempted murder, drug trafficking, robbery and theft, fraud, misconduct in public office, trafficking in persons, rape, grievous sexual assault, to name a few of the matters. These matters are being processed with alacrity. They are being pushed through our criminal justice system. We have received very favorable mention from the Financial Action Task Force in particular. And if you have regard to the FIU's report laid in Parliament a matter of 2 weeks ago, that is the annual report of the FIU ending September 30th, 2020, that report, which demonstrates a significant uptick in investigation and reporting in the period, we received for that year 1,831 suspicious transaction reports and suspicious activity reports, representing an 80% increase from the previous reporting year. And that translated in dollar and cents matters to approximately $27 billion in suspicious transactions, 97% of which were blocked by virtue of mechanisms that we introduced into law. The report of the FIU is something that I recommend all members have a look at. It is effectively, and I'm going to say this quite boldly, an ode to government. It reflects upon all of the legislation that the government brought in the period 2015 to 2020, which resulted in the significant uptick in detection and blocking of criminal activity. To have a 97% block of $27 billion, Madam Speaker, is no small feat. And therefore, the amendment today before this House is intended to carry forward the very exercise of, in particular, the follow the money matters. Those money matters that relate to an international dynamic, those matters that foreign jurisdictions have asked us to have a look at with sincerity, form the backbone of these particular amendments. I look forward to the contributions of my learned colleagues as to any improvements that may be considered, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Mutual Assistance in Criminal Matters Act, Chapter 11, 24, be now read a second time. Member for Barataria Sanwan.
Thank you very much, Madam Speaker, for recognizing me to join this debate on the Mutual Assistance in Criminal Matters Amendment Bill 2021. And I was very surprised that normally I know the Attorney General will use up all of his time, but it's a very short bill before us, dealing with one very substantive clause in the particular bill, which is Clause 3, that deals with, as the Attorney General outlined, how Trinidad and Tobago now operates in the global environment when it comes to multilateral treaties and those countries that are not considered to be part of the Commonwealth countries. Now, Madam Speaker, what we're dealing with is an amendment to Section 33 of the Act. And Section 33 of the Act already has a mechanism whereby Trinidad and Tobago can, in fact, lend and offer mutual assistance in criminal matters to non-Commonwealth countries. But with a literal and strict interpretation and reading of Section 33 of the Act, it seems as though that we are restricted to bilateral treaties between countries, that is Trinidad and Tobago and a non-Commonwealth country, and that treaty provides for mutual assistance, and then on an application to the Attorney General, who is considered the central authority, then sharing will begin. When I read the particular amendment in this case, it's very similar. However, when you look at the interpretation note, the explanatory note, it deals with, and as the Attorney General outlined, that a treaty in this instance would mean a multilateral treaty, is that if Trinidad and Tobago is a party to a multilateral treaty, this is my understanding of the government's position, if Trinidad and Tobago is a party to a multilateral treaty, and there's a non-Commonwealth country who is also a party to that multilateral treaty, where there are no provisions or arrangements for mutual assistance, then the Attorney General, by order subject to negative resolution of the Parliament, can declare that treaty as an arrangement to provide for mutual assistance. Now, that will allow for some sharing of the information between countries. As the Attorney General rightfully stated, that there are 3 jurisdictions whereby Trinidad and Tobago we have mutual assistance agreements, and that is Canada, that is United Kingdom, and that is United States of America, and the USA being the only country that is not within the Commonwealth. But, Madam Speaker, there are other provisions of the law that may seem to be very relevant, or whether or not we're creating a duplicity within the law in terms of whether or not we can use other provisions of the law to allow for sharing. I wouldn't go too much in that. My colleague would in fact explain those matters, Madam Speaker. But that is to say, in the present circumstances, whether or not this is required, or we can rely on other provisions of the law. So that is one point. The second point I want to make, Madam Speaker, is this, is that what is the clear intention for us to share information now? Is there deficiency within our current framework that prompted this Parliament in order to bring this amendment to this particular act? And I say this, Madam Speaker, because the Attorney General said that Trinidad and Tobago are parties to various multilateral treaties. And I want to pay attention to one particular treaty, and that treaty deals with mutual assistance in tax matters. That is part of what we call the Global Forum scheme. And in the Global Forum scheme, Madam Speaker, Trinidad and Tobago, well, based on their last report, is not a signatory to that treaty as yet. And that is very instrumental, because we have signed up for the Global Forum, 1. 2, we have not been able to reach our standards and fulfill the criteria of the Global Forum. And 3, Trinidad and Tobago ended up on the blacklist since 2016, and up until this day, we cannot come out of that blacklist. Madam Speaker, you would remember in the last Parliament, we were told by this government that we had to amend some parts of the legislation and also pass a particular bill called the Multilateral Convention on Mutual Assistance in Tax Matters. We were told that we have to pass the Tax Information Exchange Agreement Act. We were told that we had to amend the Income Tax Act. Madam Speaker, we did all of these things.
This is not tax information we're discussing, it's mutual assistance in criminal matters. I didn't want to interrupt because it was partly relevant, but it is now beyond, in my respectful view.
So, Member for Barataria-Sanwan, I share the view of the Attorney General that this is not about tax matters. And while I initially understood what you're trying to do, I'm going to give you a very narrow breath. Okay? So let me see where you're going with this, but you are really on the edge.
Thank you very much, Madam Speaker. And Madam Speaker, you see, the thing is, what is very relevant is that this particular amendment deals with mutual assistance in criminal matters, which is right, I admit that. And part of the Global Forum scheme and the Multilateral Convention is to in fact trap offenses that are related to tax matters that fall within the criminal ambit, the exchange of information within the criminal scheme. Because when we signed on to, when we indicated to the Global Forum that we are going to sign that convention, we said that Trinidad and Tobago is ready to fight tax evasion, which is a criminal offense in Trinidad and Tobago. And that is where I'm going, Madam Speaker, because we have to understand how this particular amendment will now work with the laws that are existing that will be applicable to it, which is the multilateral convention that is already incorporated as an act of parliament on the 12th of March 2020 in this current parliament. And I'm asking, Madam Speaker, whether or not this particular amendment today that we're dealing with is relevant to that multilateral convention relating to the Global Forum in order to take Trinidad and Tobago off the blacklist. That is what I want to find out. Because, Madam Speaker, we were told if we did not pass that particular piece of law that we would lose correspondent banking. We were told that we needed to pass that law.
I'm not going to let you go into that law. You've asked a question, and to me, that's it as far as this remains, which is before us. So I'm not going to let you go into the legislation with the Global Forum. Okay? What we're dealing is with what is before us.
Yes.
Yes.
Madam Speaker, with respect to the double taxation treaties, which is also part of the exchange of criminal matters, we already have 16 double taxation treaties. The Attorney General listed all of them in his contribution. Again, I'm asking whether or not, if we pass this particular piece of law, we want an accurate answer from this government, whether or not this will in fact take us off from the Global Forum blacklist. Because it's important for us to come off of that blacklist. And Madam Speaker, what we have seen in this amendment is that we are going to widen the scope now, but there's also need, Attorney General, and I would ask you to consider this, is that whether or not we can make, I know the other provisions of the particular piece of law that resemble this have order for negative resolution. I'm asking whether or not we can go by way of affirmative resolution, simply because this particular arrangement that we would intend to enter into will in fact be going with respect to multilateral treaties. It's not a bilateral treaty, and also where there were no provisions for mutual assistance. So it gives a little more scrutiny, it gives a little more oversight over the particular treaties that we will be enforcing for the exchange of information. That is one point. The other point, Madam Speaker, deals with, and I'm looking at Attorney General at Section 41A of the Parent Act, which is very similar to this particular piece of law. And there's also one additional criteria in Section 41A, which says that where a treaty has been concluded, whether before or after the commencement of this act, between Trinidad and Tobago and any other territory, providing for mutual assistance in any criminal matter arising or a criminal offense committed in Trinidad and Tobago or such other territory. Now, on reading of this bill, it doesn't require that a criminal offense be committed in Trinidad and Tobago or that other territory. So I was wondering whether or not that is in fact a deliberate omission because you want to capture a certain aspect of the law that Section 41A wanted to capture. So that is one of the queries that I would like to raise when it comes. Maybe we can discuss that at the committee stage of the bill when we're having a final glance of what is before us. And Madam Speaker, I know, and you already indicated that the scope and the ambit of this particular bill is very limited, and I thank you very much.
Member for Port of Spain North, St. Anne's West.
Thank you very much, Madam Speaker. Madam Speaker, I am not going to break the trend, and a welcome trend, if I may call it that I see here this afternoon, with the speakers before not utilizing their full amount of time. I was wondering what would be the debate on really a 3-clause bill where it's only one substantive matter that we're being asked to deal with here today. Madam Speaker, I'd like to use my time, respectfully, through you, to just assist the public and those who may have to read the Hansard later on to put this particular insertion into context and to explain to the public through you, Madam Speaker, what really is meant by mutual assistance and MLATs, as we call them, in the legal world. The best way to do so is to explain the whole chain of custody and evidence that must be put before a court for a criminal prosecution, because that is what the vast majority of MLATs, mutual assistance, requests for mutual assistance in criminal matters, comes down to. And to explain that to build out a legal case, one requires evidence. To gather that evidence, one of the most critical components is to have a proper chain of custody, meaning that this went from point A to point B, this is how it then went on to point C, etc. Utilization of mutual assistance in criminal matters, I listened to the 2 previous speakers. Today, in this day and age, in the globe and the global economy and the type of global criminality that we're facing, this is of critical importance. So I couldn't understand, still hasn't been explained to me, how there could be any resistance to this particular bill here this afternoon. I think the best example, Madam Speaker, to give, or one of the best examples to give as to the utilization of this particular legislation is with respect to following the money. So you see, in this day and age where there's corruption, quite often what you have is persons who've engaged in corruption then filtering that money from bank accounts locally to foreign bank accounts and to other jurisdictions. And when you've followed the money, you now need to build out that evidential chain. So you need to show that the money went from maybe this contractor, this award of a contract, to then this payment to a third-party entity, and then from that third-party entity to the subject person of interest, who may then send that money onwards, maybe to the United Kingdom, maybe to the United States, maybe to Canada, maybe to India as well. And to now prosecute that person and to follow the chain, you have to make the requests. The criminal investigators make the requests through the Attorney General's office, the central authority, who will then in turn send on a request pursuant to this particular legislation to the various jurisdictions. So can you please tell me whether there are bank accounts in the name of person X who is a national of Trinidad and Tobago between these periods of time, etc. And that's what this parent body of legislation can be utilized for. So in the fight against corruption, in the following of the money schemes in the criminal courts, you have to make MLAT requests. Also, if, for example, you're investigating, let's say, a $400 million scheme where criminal entities were and their allegations with respect to certain former ministers, etc., you want to now build out the evidence from a witness who may be now in a foreign jurisdiction. Again, you go through this scheme to protect the evidence, to allow the law enforcement officers in that jurisdiction to interview person X in that jurisdiction and allow the information, the evidence, the documents, whatever it may be, come back through this whole mutual assistance in criminal matters piece of legislation. And today what we're doing is we're amending it. And as we heard the Attorney General say, What you're now looking to do is you're looking to include multilateral treaties. And for the layperson, what that is, whereas before, and in annex to the parent legislation, we have treaties with the United States, with Canada, with the United Kingdom, with other Commonwealth countries, you're now having that you've signed up to a treaty where there are a number of different parties. So it's no longer bilateral or one-on-one Trinidad and Tobago and the United States. It might be the OECD countries. So we're now having the benefit of signing on to a treaty there. And you can now go to Brussels, you can now go to Belgium, the Netherlands, Spain, Italy, etc. in that whole exercise. And this provision is going to allow for that, where they're both parties to a treaty, that we can get that mutual criminal assistance with respect to the criminal investigations that are taking place. And just to let the population again know through you, Madam Speaker, there is nothing new about this. In fact, there are these types of bodies, organizations set up in the Department of Justice in the United States, in the United Kingdom as well, to receive these requests for mutual legal assistance in criminal matters. But today what we're doing, as the Attorney General said, is he's trying to build out a simpler process for multilateral treaties where there are more than one party signed up to those treaties by definition. There was a lot of talk, and I'm sure the Attorney General will deal with it in his wrapping up from the previous speaker about global forum and the blacklisting, etc. None of that is relevant here today. What we're being asked to do today is just expand this parent piece of legislation to allow for multilateral treaties for non-Commonwealth countries, for others, that the Attorney General may, by a simple order, subject to negative resolution of Parliament, declare that that treaty is an arrangement to provide for the type of examples I've sought to give. Madam Speaker, without any further ado, I also would like to just say that there is absolutely, and I always wait and listen for the red herrings, always wait and listen for the misinformation, for the attempts to mislead the population. As night follows day, that is exactly how the member for Barataria Samoa started off his contribution, unfortunately, by throwing out this red herring of, is this creating duplicity? And then warning us that a speaker to come will try to enhance this. I put on the record here immediately that that is absolutely false. There is no merit in that whatsoever. It is the typical attempt to mislead. Because by definition, the only way you can have mutual assistance in criminal matters to fulfill the chain of custody, to fulfill the evidential burdens, to assist in a criminal prosecution is through the parent legislation here. So the same way it has been suggested in other legislation, well, don't support this legislation because it can be done via other means. I put that to rest here, hopefully now, through you, Madam Speaker. That is completely untrue. There is no other piece of legislation that exists that will fulfill the chain of custody, the necessary tick boxes for evidence in criminal matters, but the parent legislation here today. So, Madam Speaker, without any further ado, I'd like to thank you for the opportunity to have contributed to this very short piece of legislation, 3 clauses, and to offer my full support for this bill because it is necessary in today's day and age when fighting corruption. Thank you.
Member for Naparima.
Thank you. Thank you, Madam Speaker. Today, we are here to amend this legislation by the insertion of Section 33, 1A and 1B, an amendment to Section 33, 2. So put simply, Clause 33, 1A deals with providing assistance in criminal matters to non-Commonwealth countries when no bilateral arrangement exists between them. So, just stated hypothetically, to give a hypothetical example, if Trinidad and Tobago does not have a treaty for assistance in criminal matters with Brazil, and Trinidad and Tobago has signed the Inter-American Convention on Mutual Assistance in Criminal Matters under the OAS, and actually there's A55, But Brazil has also signed that treaty under the OAS. So the OAS has the multilateral treaty, that's the Inter-American Convention on Mutual Assistance in Criminal Matters. Brazil has signed and Trinidad has signed. Then if Brazil requests assistance in criminal matters from Trinidad and Tobago, it will be as if Trinidad and Tobago and Brazil have a bilateral arrangement between them to provide for assistance to each other in criminal matters. So, Madam Speaker, a premise to this legislation is the fact that we have entered into, or we intend to enter, and the Attorney General has listed a number of multilateral treaties which we have signed. But it seems to me, when I look at the number of multilateral treaties, we in need of signing and ratifying many of them. I could give a whole set of examples, but that is a prerequisite for the operationalization of this legislation. I'll just give one example. It is taken from the official Journal of the European Union, 26 February 2021, and the Council conclusion, and I quote, Trinidad and Tobago does not apply any automatic exchange of financial information, etc., but it goes on to say, we have not signed and ratified the OECD Multilateral Convention on Mutual Administrative Assistance as amended. I will not labor the point, except to say that they are critical multilateral treaties that need signing. We need to either do them pari passu or sign the treaties and have the mechanisms to provide assistance in criminal matters. The other point I'd like to raise, Madam Speaker, is the fact that if we are moving into the global arena where we are signing multilateral treaties, a critical component of that is the operationalization of the mechanisms for which the mutual assistance can be granted. And the basis for that is the central authority in Trinidad and the central authority in the country making the request under a bilateral treaty to which both have signed. But, Madam Speaker, first world countries have a detailed mechanism for operationalizing their systems of exchanging information. For example, Madam Speaker, and I won't go into detail, just to make the point that we need to not only pass the law, but have the mechanisms to operationalize the law. And it is saying, if we look at Brazil, if we look at Argentina, if we look at Canada, the United States, they would give you a detailed, you could go on the net and get a detailed step-by-step system for interacting in order to operationalize this treaty. For example, if you look at us Argentinians, I could go on the net now, if I am a country interacting with Argentina, and I could see a step-by-step, it will indicate the principles under which the arrangement for exchange of information on criminal matters. It will indicate whether the request is made under a treaty or a convention, whether it is a non-treaty request, whether step 3 is dual criminality is generally not required. The central authority, they give you contact persons. They tell you the step 1 is to consult with the Argentine Central Authority before submitting the request. Step 2, indicate the mechanism used to seek assistance. Step 3, identify the authority conducting the investigation or prosecution. This is in the country making the request. 4, summarize the case. 5, set out the applicable legal provisions. 6, identify the assistance being sought. I could go on and on. It's about 40 pages, but it tells you that passing law is not adequate if we do not have a mechanism in Trinidad for a country seeking to get assistance from us. Madam Speaker, My main point today is whether this amendment is necessary at this time, and further, is the Attorney General already empowered to enter into arrangements for mutual assistance in criminal matters with non-Commonwealth countries? So the question basically is, do we really need this amendment? We are here today to create legislation to amend Section 33 of the Mutual Assistance in Criminal Matters Act by inserting subsection 1A and subsection 1B. Madam Speaker, the wording of the new subsection 1A is repeated practically verbatim or word for word in Section 32 of the Anti-Terrorism Act. Madam Speaker, if this already exists in the Anti-Terrorism Act, there is no need for an almost identical section in the Mutual Assistance in Criminal Matters Act. So the question is, are we wasting time? And I will read Section 30 of the Anti-Terrorism Act. And it states, and it will show how the Attorney General is already empowered to enter into an arrangement if countries are signatory to a multilateral treaty. I'll read Section 2 of Section 30, subsection 2 of the Anti-Terrorism Act. It states, where Trinidad and Tobago becomes a party to a treaty, and that treaty, it's understood in the explanation to be a multilateral treaty or a bilateral treaty. So where Trinidad and Tobago becomes a party to a treaty, and there is no arrangement between the government of Trinidad and Tobago and another state which is a party to that treaty for mutual assistance in criminal matters, the Attorney General may, by order subject to negative resolution of Parliament of Trinidad and Tobago, and the state providing for mutual assistance in criminal matters in respect of offenses falling within the scope of that treaty. So what this is saying essentially is if Trinidad and Tobago is party to a multilateral treaty, a treaty which could include a multilateral treaty, and there's no arrangement between the government of Trinidad and Tobago and that state, which is a party to the Treaty for Mutual Assistance in Criminal Matters, the Attorney General may, by order subject to negative resolution of Parliament, treat the treaty as an arrangement between the government of Trinidad and Tobago and that state providing mutual assistance. It already exists in the Anti-Terrorism Act. And I'll prove later on that this is not only applicable to the Anti-Terrorism Act, it has applicability beyond that. Now let us compare that to the proposed Section 33, subsection 1A of the Mutual Assistance in Criminal Matters before us today. And it reads, where Trinidad and Tobago are a non-Commonwealth country, the ATA, the section under the ATA says when Trinidad and Tobago becomes party to a treaty and there's no arrangement between Trinidad and Tobago and another state could be a Commonwealth state or a non-Commonwealth state. So the question we're asking today is, why the need for this legislation? But I'll read in detail what is before us. Where Trinidad and Tobago and a non-Commonwealth country are both parties to a treaty concluded whether before or after the commencement of this act, and which contains provisions dealing with criminal matters between Trinidad and Tobago and that country, then upon application of that country for assistance, the Attorney General may, and I will talk about the problem about may, that discretion, by order subject to the negative resolution of Parliament, declare the treaty as an arrangement to provide mutual assistance in criminal matters in respect of criminal matters falling within the scope of that treaty between Trinidad and Tobago and that country. Almost word for word, Madam Speaker. One can even argue that the amendment before us is weaker and more limited than the clause in the Anti-Terrorism Act. I mention this because the first page of the Mutual Assistance in Criminal Matters Act, which is the parent act, Madam Speaker, it says that this act, the parent act, is amended by 7 of 2001, 14 of 2004, and it says 26 of 2005 by implication. So the Parent Act already has sight of the clause, the relevant clause in the Anti-Terrorism Act. And it implies that it says by implication, it is understood to be part of this act. And if we had doubt, Madam Speaker, the note to the act, this is the Mutual Assistance in Criminal Matters Act. The note on the act, number 26 of 2005, this is where the Parent Act that we are amending has sight of the anti-terrorism clause. It says on page 2, see section 30 of Act number 26 of 2005, which would enable a treaty to which Trinidad and Tobago is party to be used as the basis for mutual legal assistance in criminal matters in respect of offenses falling within the scope of that treaty. So this Parent Act, the mutual assistance in criminal matters, has sight of the clause, the relevant clause in the Anti-Terrorism Act, and it notes it in page 2 of the Parent Act, which we are amending. So we are amending something which the Act already has sight of and has indicated that it has relevance to the situation here today. But Madam Speaker, sometimes the question may come whether this clause is relevant only to the Anti-Terrorism Act, Madam Speaker. So sometimes when you want to find whether it has applicability beyond the Act, you go to the debate in Parliament at the time the ATA was debated. That's the Anti-Terrorism Act was debated. And Madam Speaker, Section 30 of the Anti-Terrorism Act, which is under Part 4 of that Act, was mentioned by the Honorable Fitzgerald Hines in Hansard on the 11th of February 2005. So we look to say what was debated when they debated the Anti-Terrorism Act, and the debate envisage that it should have applicability beyond the Anti-Terrorism Act. And I quote from the Honorable Fitzgerald Hines. At that time, he was the minister in the Ministry of Minister of State in the Ministry of National Security and in the Ministry of Industry and Trade. And this is what he said. I quote, this is from Hansard. Part 6 of the Anti-Terrorism Act deals with information sharing, it deals with extradition, and it deals with mutual assistance in criminal matters. He goes on, as part of the international community, Trinidad and Tobago must be cognizant of the international issues and must, as far as possible, implement measures adopted at all international fora. This is the very purpose of Part 6 of the Anti-Terrorism Act. It has to do, as I said, with information sharing, extradition of persons when necessary, and mutual assistance in criminal matters. Clearly, the fact that this parent bill cites by implication that clause in the Anti-Terrorism Act, and in the debate, the discussions indicated that it went beyond the Terrorism Act to have applicability beyond. And so therefore the question we ask is why are we here today, right? Now, let's see the key differences between the current provision under the ATA, which we submit empowers the Attorney General to enter into bilateral arrangements with countries that are signatory to a multilateral treaty to which we have signed. The key differences between the current provision under the ATA and the Mutual Assistance in Criminal Matters Amendment is one. Section 30, subsection 2 of the ATA deals with treaties between Trinidad and Tobago and a state. Section 33, subsection 1A, by contrast, of the mutual assistance in criminal matters is limited to treaties between Trinidad and Tobago and non-Commonwealth countries. So the ATA is broader, and we submit that it already empowers the Attorney General to enter into arrangements for exchange of assistance in criminal matters. Second difference, subsection 30, subsection 2 of the Anti-Terrorism Act relates to any treaty to which both parties are signatory, and there is no arrangement between the parties for mutual assistance in criminal matters. Whereas what is before us today is more limited, in that section 33, subsection 1A of the mutual assistance in criminal matters is specifically limited to treaties to which both parties are signatories and which contain provisions dealing with criminal matters. And there is no arrangement between the parties for mutual assistance in criminal matters. The provision is broader in the ATA as it deals with any treaty, not just ones which contain provisions for criminal matters. And Speaker, Section 30, subsection 2 of the Anti-Terrorism Act cannot be applied retroactively, and this is the fundamental difference. Right? And as such can only apply to treaties to which Trinidad and Tobago becomes a party from the date of enactment of the Anti-Terrorism Act on 13 September 2005 and onwards. This amendment speaks to the question of retroactivity when it says that in amendment section 33(1)(a) of the mutual assistance in criminal matters include treaties that were concluded before or after the commencement of the act. Madam Speaker, when we get into the matter of retroactivity, it requires a level of legislation and review and information that is greater than what was provided here today by the Attorney General. We're getting into fundamental rights that exist today. When this amendment is passed this afternoon, we might find that the individual citizens do not have those rights because the retroactivity clause kicks in. So to get a thorough idea of the implications of this amendment, we would need a comprehensive list of the multilateral treaties that Trinidad is already signatory to, and how does it apply in terms of the rights of citizens. And I'll ask the Attorney General to provide a list of all multilateral treaties that we have signed so far, so that we could have, and not only just list them, but let us have some sight of them so that we could have a clear understanding of the rights that citizens had before and whether they will be changed with this amendment. So the issues we face today, fundamental issues, there's going to be interpretational problems. In fact, the staff had strong words. Poor drafting is bound to create interpretational problems. Determining whether and to what extent Section 30 of the subsection 2 of the Anti-Terrorism Act has been repealed and or replaced and or amended. The second issue, to what extent Section 30, subsection 2 of the ATA, Anti-Terrorism Act, would still remain applicable to mutual assistance in criminal matters. A third difference, whether there will be a conflict between the two pieces of legislation and how will they operate. Are they to operate simultaneously, or will one supersede the other?
Member for Naparima, I guess you're most probably summarizing, but your time is now spent.
It's time spent.
Member for Laventille West.
Thank you very kindly for recognizing me, Madam Speaker. Madam Speaker, I have listened to all of my colleagues in this House who have spoken in this debate hitherto. And Madam Speaker, I find substantial disagreement with the submission made by the member for Naparima. He quoted yours truly in that anti-terrorism bill debate. And while the terms of that legislation says what it did, and while one concedes that it is of broad application, the member for Naparima was really telling us here today, in light of that provision in the anti-terrorism law, we should not, it is not necessary for Trinidad and Tobago to engage in mutual assistance treaties otherwise. A ridiculous proposition that only has to be stated to be rejected. Madam Speaker, that was terrorism law. And this measure today, or in fact in the Mutual Assistance Treaty, one of the offenses that it considers in its dispensation is terrorism, with money laundering and all the other elements as outlined by the Attorney General. So one understands that there is some kind of link between them, but certainly the member cannot be telling us today that we then need not have bilateral arrangements with any country in respect of mutual assistance in criminal matters. I reject that. The member gave the example of Brazil, and on his own example, I submit, Madam Speaker, we will need a bilateral treaty with Brazil in the context of the example that he gave. But I don't want to spend all my time on the member for Naparima, so let me press on. As I said, I have listened to my colleagues. I listened particularly to the Attorney General. I heard my own view, and I heard the member for Naparima allude to it, but he said it in the context of you need to have, it is no point just passing this law, you have to have clean procedures listed. And if he went on the Brazil website, he will find, or Argentina, he will find all the principles and the methods by which they would go through this. The member didn't take time to look at the first schedule of the parent legislation, the Mutual Assistance in Criminal Matters, Chapter 11-12, which we are amending today. And if he had looked in that first schedule, he will see at item 1, it outlines cleanly and clearly some of the matters that Trinidad and Tobago in this treaty are obliged to, and in fact the Central Authority on every occasion pays attention to. In that first schedule, it talks about a request made under this act by a Commonwealth country shall specify the assistance requested, be initiated by a judge, magistrate, or director of public prosecution or law enforcement agency, identify the person, agency, or authority that initiated the request, and it goes on. Apart from which, we have been engaged in this mutual assistance arrangement since the passage of this law, and even before, through diplomatic means by what they call letters. There were some diplomatic procedures by which states assisted, rogatory, assisted each other. So we are well schooled in this. And we are the subject of international agreements, as you have heard. We are parties to international agreements, and we have been doing this successfully all the years. It means that the procedures are sufficiently known and sufficiently designed and meet the international standard for sharing assistance. So for the member for Naparima to suggest that we need to do that is almost like negotiating for what you already have. And that too has to be rejected. But my own view is that if we pass these laws, as indeed others, and these measures, I submit that they are of no value without proper enforcement. I would rather spend my time paying attention to that. So the FIU is one of the agencies that does this kind of analysis and enforcement. The police, the customs, real estate agents, all listed businesses, all are lined up in terms of our AML arrangements. And they play a role in enforcing this kind of law in order to be able to give mutual assistance to another country or to receive information from them. Because we understand that the problem we are tackling in this amendment and with the parent law has to do with a global and transnational criminal activity, and it requires a global response equally. That is why we are part of international conventions on this matter. And therefore, all our institutions and all stakeholders must play a role in order to ensure this. We amend this law today in accordance with our Constitution with a view to good order and good governance, Madam Speaker. Public order, public safety, these are the kinds of things we bear in mind. The Minister of National Security explained in great detail how this law works, Madam Speaker. For example, the purchase of land. I had to report, Madam Speaker, just by way of an example in terms of how this works. I had to report to the FIU and the head of the investigating unit of the police service, financial investigating unit, about some transactions, about 9 of them, of land purchased by a young man called Christian. I'll go no further. In this country, and I know the matter is under police investigation. It is the will, it is the enforcement that will give life to these provisions. So I agree with the member for Naparima. If you don't have that, then these laws are of no real consequence. And I'm looking forward to it, because that young man became famous between 2010 and 2015 in Trinidad and Tobago. His name was mentioned in high political circles, male and female. So if a person purchased land, 9 pieces valued at about $20 million in the space of 2.5 to 3 years, that is the kind of matter that will gain the attention of the FIU and the police, and that is the kind of thing that this is aiming at, as the Minister of National Security referenced for us earlier today. If you don't have no will, if you don't have no fight, if the police don't have the capacity, all of this. And that is why there are some people walking around Trinidad and Tobago, Madam Speaker, shouting about corruption, offending my sensitivities as often, talking about corruption, accusing even the government of Trinidad and Tobago of corruption. And because these matters are not pursued with the vigor, because a lot of them who shouting should be in another place, they should be in jail, Madam Speaker. So when we come here to amend this today, those of us who know understand. And we also understand why there is some objection. Imagine the member for Barataria Sanwa, Madam Speaker, in this debate on 3 clauses in this amendment, tells us, nitpicking, that rather than the order, because this amendment says, when, for example, when a non-Commonwealth country wants to do business with us, wants assistance, once that non-Commonwealth, in fact, let me actually read it for you, Madam Speaker, so that we'll get the terms of it very, very clear. Where Trinidad and Tobago and a non-Commonwealth country are both parties to a treaty, concluded whether before or after the passage of this law, dealing with criminal matters, and there is no arrangement for mutual arrangement in criminal matters between Trinidad and Tobago and that non-Commonwealth country, then upon the application of that country for assistance, so if that country makes an application to us for assistance, the Attorney General, because of the facts as I have just described them, can by way of order declare that that country, that the treaty, the Attorney General can declare that treaty and see it as an arrangement to provide mutual assistance in criminal matters in respect of that country. So my example, Holland is a non-Commonwealth country. The member for Naparima tell us about Brazil. And therefore, in such cases, the Attorney General makes the order. That order and that declaration in the order is to be done by negative resolution. I heard the member for Barataria Sanwa today asking that it be done by affirmative resolution. In other words, we must bring that simple matter here and have a long debate about it. Nitpicking. I heard the member for Naparima nitpicking, wondering whether the law itself, parent law, and the amendments today are necessary because he find a clause in the anti-terrorism law that suggests that we could do business in criminal matters. And that is the posture of my friends on the other side that troubles me. With this mutual assistance in criminal matters, and with FATCA, and with all the laws that we have passed in the last few years in this parliament, follow the money laws, attempting to implement a property tax to identify every property. So in the case of Christian, I told you a while ago, we'll get to know who is the owner of every piece.
Madam Speaker, 48.1, please. This is about multilateral treaties.
But while I understand how you're trying to show that it
Yes,
is,
Madam Speaker.
please really rein it into
Yes.
debate.
And I'm saying, just like you heard from the member for Barataria Sanwan and the member for Naparima, nitpicking, looking for reasons to object to this. And again, we ask the question, why? But the point is, what is being structured here in the amendment today, because like COVID-19, which is a pandemic, internationally deadly, and it requires an international response, as you are seeing, Madam Speaker. The amendments we come here with today is to allow a non-Commonwealth country that wants assistance. So that's part of the global response. The more, the merrier, because we are fighting transnational and global criminal activity. So it's a blanket, it's a dragnet, it's a blanket to cover the whole world, so no one shall escape from the measures that we are aiming at in these provisions. Madam Speaker, and it is as simple as that, nothing more sophisticated than that. So, Madam Speaker, some of the matters, as the AG identified that the provisions will cover, has to do with corruption, money laundering, terrorist financing, cybercrime, discreditable conduct, willfully exposing a child, robbery and theft, misconduct in public office. And I said to you a while ago, Madam Speaker, if you don't have the will to fight, if you don't amend to meet the need, like how we are bringing in that non-Commonwealth country into the net, the dragnet, then your response to this international problem will be very weak. And we have players running about here in Trinidad and Tobago. They don't want to see the passage of this law because it covers trafficking in persons, rape, and grievous sexual assault as well. All of these things. So in 2020, we had 2 incoming requests for mutual assistance and 6 outgoing requests, where we requested from Canada, Grenada, Jamaica, St. Lucia, assistance. And insofar as non-Commonwealth countries, the United States of America, on 12 occasions, Poland, Colombia, we wanted information and assistance from them. Non-Commonwealth countries, very germane to what we are dealing with here today, Madam Speaker. And therefore, over the period 2016 to 2021, the total number of offenses from Commonwealth countries based on mutual legal assistance requests is 50, whereby 15 were offenses emanating from incoming requests and 35 from outgoing requests. There's a lot happening. A lot is happening around us. And we have to be alert to it. So when my friends on the other side come to show us frivolous reasons why we should not be doing these things, we have to wonder, what are they talking about? And only recently it was laid in this house, the 2020 report of the FIU, where the FIU told us that for the first time, they received a total of 1,831 STRs, suspicious transaction reports, and suspicious activity reports. 1,831. We heard the figure involved some time ago from the Minister of Finance. They also told us during this period, the FIU of Trinidad and Tobago noted a 141% increase in those STRs and SARs. Submissions from financial institutions and an 80% increase in submissions from listed businesses. I only tell you that, Madam Speaker, to say to us that there's a lot of activity taking place. Their report goes on to tell us submissions from cooperative societies, insurance companies, investment companies, mortgage companies, jewelers, and others had also increased. And this, Madam Speaker, of the 1,831 STRs, SARs received, 41% or 750 of them were primarily associated with the demonetization of the cotton-based $100 bills. This was due to Legal Notice 357 of 2019, which demonetized $100 bills bearing any series before 2019. It was noted that 142 reports of suspicious transactions were submitted by the central bank under Section 52 of POCA. That too ties in with this. When we identified there was a problem at Piarco Airport, and I can't go deeply into it, but this is already on the public record. It was the anti-money laundering dragnet blanket of the United States that identified it and informed the government of Trinidad and Tobago. In the diplomatic means, this is the legal channel by which it is done. And that is what alerted the government of Trinidad and Tobago that America found money floating around internationally, being laundered. They first thought it was drugs and then realized. So, Madam Speaker, the amendment we propose here today spreads the dragnet just a little more. And that is to collaborate with all the measures that we have taken with other laws in this country to ensure that those who have cocoa and sun must look out for rain. And I know we have plenty cocoa farmer in Trinidad and Tobago. The only problem I have, sometimes I hear from spokespersons in this very house, looking me in the eye from the other side, sounding as though, Madam Speaker, as I close, that they don't understand what cocoa farming is all about and shout the loudest about cocoa farming. Madam Speaker, I commend these measures to my colleagues and ask for their support in voting for them. Thank you very much, Madam Speaker.
Member for Port of Spain South.
Madam Speaker, the only simple minds will say that this amendment creates duplicity. The starting point must be that there's a lacuna in the legislative system. And this is because the system as it exists now limits mutual assistance in criminal matters relative to non-Commonwealth countries simply because a treaty between the parties does not provide for mutual assistance in these matters. By this amendment, that lacuna is cured. As long as there is a treaty between Trinidad and Tobago and a non-Commonwealth country that contains a provision dealing with criminal matters, assistance can be granted mutually in any criminal matter. The fault in the Act, the fault in the legislative framework is being corrected now, and I want to commend the Honorable Attorney General and all my colleagues for making that provision and fixing it now. These proposed amendments, simple as they are, strengthens the reciprocity in cooperation in criminal matters between Trinidad and Tobago and non-Commonwealth countries. And as all responsible nations recognize, there is a need for cooperation and mutual assistance. And the reason for that, Madam Speaker, is because the criminals and the criminal enterprises are cooperating themselves and consulting across the borders. Therefore, in response to that, there is a need for a modernized scheme that has expanded its ambit to meet globalized criminal activity. And this is what this amendment is geared to achieve. With this amendment, Madam Speaker, mutual assistance will go beyond our geographical neighbors and historical partners. The amendment is very important for Trinidad and Tobago because it recognizes, Madam Speaker, that due to the geographical location of Trinidad and Tobago, there's a prime location for the transshipment of illegal drugs and other illegal activities such as money laundering, illegal trafficking in humans, illegal trafficking in firearms and ammunition, and offenses related to corruption. And Madam Speaker, this bill is important, and this amendment is important because the international criminal knows no boundaries. Crime has now become transnational in nature, more so money laundering, where dirty money, Madam Speaker, can be moved from jurisdiction to jurisdiction by the mere click of a button. The government, being now aware of the dangers of money laundering, counter-financing of terrorism, human trafficking, now knows and recognizes that we cannot exist in isolation and keep doing business with our traditional partners. International cooperation is now the cornerstone of good governance, and this government remains committed to good governance both nationally and internationally. Madam Speaker, borders are now borderless. Criminals traverse the world with impunity, and transnational crime is a problem. And the government, by this amendment, recognizes this and is trying to fix it. This amendment is a simple one. It's a simple one because what it allows, Madam Speaker, is that it deals with crime as being transnational, and it recognizes it can take place anywhere in the world. And the lawmakers, and as lawmakers, we have a duty to do our best to stop crime. What this amendment does, it allows Trinidad and Tobago and Panama who have signed on to a treaty, for example, the United Nations Convention Against Corruption, allows Panama to make a request to the Ministry of Legal Affairs for assistance in criminal matters. May I continue, Madam Speaker? And by this amendment, Trinidad and Tobago can assist countries who have signed on to, for example, the United Nations Convention in Narcotic and Drugs. That convention is, I think, the 1961 convention. The UN Correction Illicit Traffic in Narcotics, Drug and Psychotic Substances Vienna Convention. The UN Convention Against Transnational Organized Crime of 2020. And the UN Convention Against Corruption in 2003. Madam Speaker, this bill is by no means novel because in Canada, for example, there's the Mutual Legal Assistance in Criminal Matters, which came into force in October 1998 and allows for legal assistance in the absence of an agreement. So it proposes nothing new. I don't know what is the nitpicking. I don't know what is the furrow. And this amendment, we say, is good law because it will enable Trinidad and Tobago to join in and play its part in the fight against transnational organized crime. Madam Speaker, in my research to make this presentation today, I came upon a speech as it relates to this very type of amendment for the then Secretary General of the United Nations, Kofi Annan, in 2004. And this is what he had to say about the scourge of international criminal activities. He said that criminal groups have wasted no time in embracing today's globalized economy and the sophisticated technology that goes with it. But our efforts to combat them have remained up to now very fragmented and our weapons almost obsolete. The convention gives us a new tool to address the scourge of crime as a global problem. With enhanced international cooperation, we can have a real impact on the ability of international criminals to operate successfully and can help citizens everywhere in their often bitter struggle for safety, dignity in their homes and community. We say that this simple piece of legislation, as it is far-reaching, but has that effect to obliterate or to reduce or to ameliorate the scourge of international organized criminal activity. Madam Speaker, this government says that we are based on solid, sober governance. And let he who have ears hear and those who have eyes see, because the ill-gotten gains that have been skirted away from this country and elsewhere, we want it back. And Madam Speaker, this government does not exist in any la-la-la-la land, you know. This is a government of solid policy. And as I end, I think of the immortal words of David Michael Rudder. Madam Speaker, I go into Panama. I got to go to Panama because we know who they have over there and we want our money back. Madam Speaker, I rise to support this amendment and I commend the Honorable Attorney General for its introduction, and I hope that all right-thinking honorable members in this House supports this piece of legislation, and I thank you.
Attorney General.
Madam Speaker. Madam Speaker, I wish to thank my honourable colleagues for their contributions. And I wish to say that I was honestly surprised today by the contribution for Naparima. Genuinely. And I say this most respectfully. Whoever wrote that speech for the honourable member, in terms of the research done, came very close to identifying one of the real issues under consideration. Unfortunately, the researcher didn't quite grasp the conflict between the Anti-Terrorism Act and the Mutual Assistance in Criminal Matters Act. I don't mean any insult to the honourable member. Clearly he was reading very carefully from the prepared text that he brought to the Parliament, but permit me to address that issue immediately. I'm sorry the honourable member is not here to listen to it. The fact is, Madam Speaker, that we of course considered the amendments to the Anti-Terrorism Act. The Anti-Terrorism Act, which was amended in 2005, and of course the member read the speech from then Member of Parliament Fitzgerald Hines in that debate in 2005. The Anti-Terrorism Act at section 30, 1 and 2 are relevant to this debate. But there is a material and complete distinction between the two that is difficult to find if you're not trained in the law, so I can understand that. But let me point it out. Where Trinidad and Tobago becomes a party to a treaty, and there is in force an arrangement between the government of Trinidad and Tobago, etc. I focus on the word arrangement. That is the Anti-Terrorism Section 31. What we propose today is where Trinidad and Tobago and a non-Commonwealth country are both parties to a treaty concluded whether before or after commencement, and which contains provisions dealing with criminal matters, and there is no arrangement for mutual assistance in criminal matters, and that country then upon. So the Anti-Terrorism Act did treat with the concept of a treaty. The Anti-Terrorism Act went on to say that this is important, Madam President, Madam Speaker, for the record. Section 31 says, the arrangement shall be deemed for the purposes of the Mutual Assistance in Criminal Matters Act to indicate provision for mutual assistance. The arrangement. What we are doing today is we are bringing to life the treaty. And we do that because our system of law is a dualist system of law. International conventions, including the Committee of Countries where you have reciprocity, etc., international conventions are not automatically upon execution or ratification made law, because there is a distinction between the prerogative power, if we recall our constitutional law training, the prerogative power is different from the Parliament's power. And if I translate that, in the United Kingdom system of laws, the Crown has the power to enter into law by treaty. Forgive me, the Crown has the power to enter into treaty. And a treaty is exercisable on the prerogative of Her Majesty. The Parliament has made it abundantly clear, and the courts in interpreting the laws of the United Kingdom say that is not to be confused with the power of the Parliament and only the Parliament to make law. So what we propose today in the amendment to Section 33 of the Mutual Assistance in Criminal Matters Act is to provide the mechanism for the treaty, because here is what we say. The Attorney General will, by order, subject to negative resolution of Parliament, declare the treaty as an arrangement. So there is a material difference between the arrangement having effect under the Anti-Terrorism Act and the treaty having force of law in accordance with our reception of laws principle, which is the dualist system of law, where we need to take an international event, a treaty, a multilateral treaty, and make it primary law by way of an act of Parliament, or in this case, an order which is a subsidiary piece of legislation. And there's nothing wrong with orders. One need only look at the Tax Information Exchange Acts, etc., and you can see that this is a tried and tested mechanism of the law. So, to answer the contribution for the honourable member from Naparima, there is no conflict between the Anti-Terrorism Act Section 30 and the proposed amendments to Section 33 of the Mutual Assistance in Criminal Matters Act. And very importantly, because we want to operate within the robust structure of mutual assistance, search and seizure, arrest, interrogation, the hard side of mutual assistance, we want to make sure that there is no challenge to the non-Commonwealth country's request, because people now say, well, look, you made the arrangement in the Anti-Terrorism Act, but you didn't declare the treaty to have effect, and therefore you are acting ultra vires the Constitution. So what we are doing today is a very careful, studied, and prepared approach to the amendment of the law, and that is why we propose to amplify the provisions in the Mutual Assistance of Criminal Matters Act, as opposed to just relying upon the arrangements via treaties in Section 30 of the Anti-Terrorism Act. Permit me to address one further point, Madam Speaker, and that is tax information exchange in the context of the Global Forum, as raised by both Naparima and Barataria Sanwan, is not what we are on about. There is a connected relevance which both members addressed, and that relevance is that the treaty for double taxation or tax information under the Tax Information Exchange Act or under a double taxation relief arrangement, that is something which may contain provisions for mutual criminal assistance. Insofar as that is the case, it is important to say what we are on about is the police power and the judicial power, which is an amplification to the letters rogatory arrangement which exists from non-Commonwealth countries. And let me explain that. Letters rogatory are basically a foreign court in a non-Commonwealth country like France or Denmark or wherever else. Their courts issue a request to Trinidad and Tobago under our Mutual Assistance in Criminal Matters Act. That judicial request is called a letters rogatory. That letters rogatory comes to the Attorney General under the Mutual Assistance in Criminal Matters Act, because the Attorney General is the point authority as the central authority. That administrative arrangement is not as powerful because the Mutual Assistance in Criminal Matters Act did not give the breadth of powers to non-Commonwealthers as they did to the Commonwealthers. And so far, the only country that is the beneficiary of an order as a non-Commonwealth country, in our laws, is the United States of America. Recognizing, as the member for Port of Spain South said, that we are now borderless and that crime is borderless. Cybercrime, money laundering. And I want to thank the Minister of National Security because he painted some very significant examples that people can relate to. Examples of corruption and the flow of monies, etc. In fact, the member for Port of Spain South referred to this being no la-la land, and that Panama Papers obviously comes to mind. If you look at the Panama Papers scandal and the la-la land example, you will understand, double entendre included, that we are talking about people that leave this country and run with their money into countries that have no extradition laws. Panama has no extradition law. Trinidad and Tobago cannot extradite people from Panama because we have no arrangement with them. So some people in a very calculated way choose jurisdictions like that. We know of the safe havens, Switzerland, we know of Panama, etc. But we also know of WikiLeaks, and we know of the Panama Papers, and we know that in Trinidad and Tobago, we have to be extremely careful about cross-border flows, and that there is a risk now in the non-Commonwealth countries, particularly the European Union. We have to pay attention to how we manage requests for assistance from non-Commonwealth countries. I need to answer, in very short and simple measure, the allegation that we are blacklisted by the Global Forum. Madam Speaker, honourable members opposite ought to know that then Minister of Finance Larry Hawaii in October 2014 went to Berlin, signed up the agreement to enter into Global Forum, undertook that Trinidad and Tobago would be ready. That required Trinidad and Tobago to enter into 17 separate treaties with 17 countries to meet Global Forum. Unfortunately, absolutely nothing was done. It took Minister of Finance Colum Imbert, the member for Diego Martin Northeast, to enter into the equation and ask the Global Forum to give us the opportunity to abandon the need for 17 treaties, which takes a decade, and instead to enter into a multilateral convention treaty. To do that, they said to us, you cannot enter this dance until you amend the law. You need to amend your tax information exchange, you need to amend your Income Tax Act, etc. And the record will demonstrate that the opposition refused to support the legislation, and therefore we were years limping along in this horrible situation. Now that the legislation was passed after song and dance and ball and gnashing of teeth, which only ended in 2020. In 2020, it's when the UNC finally capitulated to public pressure and allowed the Global Forum to be unlocked. The last steps, as I wrap up on this point, are that we cannot sign on to the multilateral treaty until we deal with the special economic zones to replace free zones, and until we deal with the base erosion profits issues, otherwise known as BEPS issues, to eliminate harmful tax practices. In those circumstances, I would again urge the opposition to just stop it. We just can't have misinformation of this type, because people in the Global Forum pay attention to what parliamentarians say, and they assume that members in Parliament actually have done the research and are comparing apples with apples. There's one final point. The European community, the Commission itself, has put Trinidad and Tobago into negative listing. They have indicated to Trinidad and Tobago that fortunately, because we passed the miscellaneous provisions registration of deeds package laws, and because we have the opportunity to create a register of trusts, that on the basis of that, together with our operationalization of administrative measures pursuant to recommendation 35 of the Financial Action Task Force, that it will lift us out of that difficulty. So we are well on our way to complete success. I say this most sincerely and not disrespectfully. No thanks to the UNC, because they refused to submit to any form of agreement until we had to literally face the gun of the international community. And I think it is a tragedy and a shame that an opposition would put a country into that kind of risk. Madam Speaker, I believe that I have traversed all of the elements. I want to indicate that the government proposes a small amendment to Clause 3, and also, in keeping with the harmony of the amendment, we propose to Clause 3 to cause an amendment in a new clause to Section 40 of the Act. And if I could just explain that for a moment. There is the room to hold a view that because Section 32 of the Act says a treaty means, and it goes through a treaty, etc., etc., when you combine that with Section 16 of the Interpretation Act, the view is that a treaty includes the plural, treaties. Out of an abundance of caution, we believe it necessary, even though it flies in the face of standard drafting practice, we think it necessary to be express that a treaty also includes a bilateral or multilateral treaty. Because we don't want to have any argument which has to be settled by the court as to what this means. The Chief Parliamentary Council is not in favor of that form of amendment, but the civil law jurisdictions, the non-Commonwealth jurisdictions who assess us, prefer to have the excessive form of explanation. In those circumstances, Madam Speaker, I have asked the CPC's department to prepare certain amendments to the bill and also to introduce an amendment to Section 40 of the Act. I have not seen that finalized amendment yet. A draft came to me which I returned as having an error on it, and I would like the opportunity to just settle that draft if you don't mind. So if we get to the stage of final position, I think my colleague, the Minister of Planning, has just received the draft. If I could just reflect upon it. This is the one that needs a tweak. So, Madam Speaker, after we move to the next stage, if I could ask for a short break just to confirm the amendment, just a 5-minute break to discuss with my team, I'd be grateful. Madam Speaker, in all the circumstances, I would think 15 minutes. In all of these circumstances, Madam Speaker, I hold the view and I submit that this law is proportionate, is necessary, it is an aid to the fight against crime. Following the money is an integral mechanism of this government's fight against crime, and we are very much anxious to get this law into effect, and I beg to move.
Okay, so Attorney General, and for the information of all members, before I put the question, I'm just going to clarify what the position is. We shall go into the committee and then suspend. All right, so we're going to go through all the stages, convene the committee, and then suspend. Yes? Okay. So, honorable members, the question is that a bill entitled An Act to Amend the Mutual Assistance in Criminal Matters Act, Chapter 1124, be now read a second time. All in favor say aye. Aye. Any against? I think the ayes have it.
A bill entitled An Act to Amend the Mutual Assistance in Criminal Matters Act, Chapter 1124.
Attorney General.
Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the Mutual Assistance in Criminal Matters Amendment Bill 2021 be committed to the Committee of the Whole.
Honorable members, the question is that the Mutual Assistance in Criminal Matters Amendment Bill 2021 be committed to the Committee of the Whole. All in favor say aye. Aye. Any against? I think the ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause. Okay, so might I ask how much time would be needed, Leader Bills?
Madam Chairman, could we have 30 minutes, please?
All right, so it means that I guess members will have an opportunity to refresh themselves so that we will reconvene at 4:45 p.m. Okay, so this committee meeting is now suspended. 4:45.